First
of all, I'd like to thank you all for attending the meeting of the Bills Committee on Pharmacy and Poisons Amendment Bill 2014. This is the first meeting of the Bills Committee. We have to elect the chairman for the Bills Committee. We've already formed a quorum, so I now call the meeting to order. First thing to do is to elect the chairman of the Bills Committee. In accordance with House Rule 21E, Appendix 4, setting out the election procedures, members will have to nominate another candidate as the chairman of the Bills Committee, and any valid nomination will have to be made verbally by one member to be seconded by another member. And the member being nominated will have to accept the nomination. First, Dr. Joseph Lee. All right. Any seconder? Is seconded by Alice Mack. Yes, Dr. Lee, do you accept the nomination? Yes, I do. Okay, other than this nomination, any other nominations? None. I then declare that Dr. Joseph Lee has been elected the chairman of the Bills Committee. So please come over and take your seat. Thank you for your support. Procedurally, I would like to seek members' views on whether or not we need a deputy chairman for the Bills Committee. No need? All right, thank you. So we will do everything together. Item 2, let's invite the administration team to join us. Thank you for coming, officials. So next, let's ask the administration team to brief us on the bill, and then for those members who would like to speak, please raise your hands. Thank you, Chairman. On the 26th of March this year, the Secretary for Food and Health moved the first reading on the Pharmacy and Poisons Amendment Bill 2014. The purpose of the bill is to implement the Review Committee's recommendations in its report for proposals that require legislative backup, and that's to clarify and update the relevant provisions under the Pharmacy and Poisons Ordinance in order to ensure that the pharmaceutical regulatory system will be more updated and comprehensive, as set out in the Secretary's opening speech. In the light of a number of incidents concerning pharmaceutical products in Hong Kong in early 2009, a review committee was set up in 2009 to conduct a comprehensive review on the existing regime for the regulation of pharmaceutical products. After examining in detail the existing regulatory regime, a total of 75 recommendations were made in the review committee's report to improve the current systems, and among the 75 recommendations, 16 require amendments to be made to the existing PPO and its subsidiary legislation. For the rest, they do not require any legislative amendments. In considering the 16 recommendations, we have engaged a consultant to conduct a regulatory impact assessment to look at the impact of implementing those recommendations, and in the process, the consultant already conducted a series of consultation with the stakeholders, and the university has also conducted one round of public consultation to understand the response from the public on the proposed recommendations. All in all, both the public and the stakeholders support the proposed recommendations in order to enhance the current regulatory regime. And after assessing the views from the public and the stakeholders, we have decided that most of the 16 recommendations will have to be implemented through legislative amendments without affecting the various parties concerned. And then we will be able to enhance the regulatory framework for pharmaceutical products in order to step up our protection for the public. And also on the 18th of November last year, we also attended the Health Services Panel's meeting to brief members on the details of the proposed bill. And relevant stakeholders have also been invited to attend a special meeting in December to give their views on the proposed amendment bill. And after repeated discussions, the Health Services Panel on the 10th of February this year at a special meeting supported our proposed amendments. That's why in the amendment bill that we tabled before this Council, with regard to the proposed amendments, we have already fully reflected the stakeholders and also the panel's views. With regard to certain concerns made by the sector and also lawmakers, we have already reflected those in the bill. In simple terms, with regard to the scope of the legislative amendments, we try to step up control in different respects, including the manufacturers, wholesalers, and also import and exporters, and also registered pharmacists and so on, in order to step up the comprehensive regulation of pharmaceutical products in order to provide better protection to the consumers. And in order to enable members to have a better understanding of the bill, I'll be setting out the highlights of the bill with regard to overall regulation in order to converge with international standards. We have taken reference from the definition of the EU, so that in the PPO, with regard to pharmaceutical products, the definition has been changed to mean a substance or combination of substances presented as having properties for treating or preventing disease in human beings or animals. And also, in response to the review committee's recommendation, we propose that with regard to the relevant manufacturers, importers and exporters, wholesalers, retailers, and also registered pharmacists, relevant code of practice and code of conduct will be issued to them in order to step up regulation of their conduct. And under the proposal, the PPB will fully consult the stakeholders. With regard to the manufacturers, one of the important amendments is to introduce a registration system for authorized persons, and it's also provided that every authorized person or seller will have to engage at least one registered pharmacist. And also, it's also clearly spelled out that with regard to the secondary packaging, that will also have to be done by licensed manufacturer in order to ensure that there will be no wrong labeling or the wrong packaging into the carton box, causing misunderstanding. And also, with regard to non-poisons, wholesalers will also have to go by a licensing system, so that the licensing system will be extended to all pharmaceutical products, including both poisons and non-poisons, and their sellers. And also for importers and exporters, the registration system and also the wholesalers licensing system will also be merged in order to streamline and consolidate the current system. And it's also proposed that for the poisons list regulation, Part 1 poison, the record system will also apply to all the transactions involving poisons and non-poisons in order to ensure that when necessary, the recall process can be expedited. And also at the wholesalers level, we will also be tightening up on the authorized sellers of poisons, including the requirement to keep poisons in locked receptacles. That would also be extended to Part 1 drugs under the poisons list regulations to ensure that all Part 1 poisons will have to be kept in locked receptacles at the registered premises of the authorized sellers of poisons, with the key kept by the registered pharmacist. That is to step up the protection afforded to the public. For the other amendments, including an order to be made by the court to recover the analytical costs that has been incurred for conducting sampling tests on the drugs concerned, and also for the legislative process that would also be streamlined in order to expedite the vetting and registration of pharmaceutical products so that patients in need of the drugs will be able to catch up with the latest medical technological development. And also with regard to poison and its definition, that might also give people the impression that it's not suitable for consumption. That's why we would like to replace it with the term prescription drug and or drug under supervised sale in order to replace the term poison on the label. So all the amendments have already fully reflected the views of the sector and also balanced the comments made by the various sectors, and it's been supported widely by all sectors concerned. We hope that members will support the amendment bill so that we can make an early improvement to Hong Kong's regulatory regime on pharmaceutical products, and if members have any questions, we'll be more than happy to take them. All right, we have 3 members who have raised their hands: Vincent Fang, Leung Yiu Chung, and then Emily Lau and Albert Chen. Vincent Fang. Thank you, Chairman. Actually, some time ago, the Secretary came here to brief us on the bill, and last time he said that he had already consulted the sector and many views have been collected. But then subsequently, we held a public hearing, and Chairman, you were also there. And then at the public hearing, many views were given to us, and the sector said that they had never been consulted. Yes, in the legislative brief, the Bureau might have changed its stance, but then I think we should hold another public hearing because there are many suggestions which have yet to reach a consensus amongst those who are concerned. Well, with regard to the term medicine and also for the drug orders and so on, well, I support that so that you can have a very clear record-keeping system. The reason why we have to do it was because last time there was the wrong prescription by doctors and also the wrong delivery of drugs. So we are trying to stop that. But then if you look at the current bill as it is drafted, well, it only provides that you are responsible for regulating the sale of drugs, and also is about the sale of drugs. But then how about doctors' clinics prescribing or dispensing the wrong drugs and so on? And also, in some cases, there is no pharmacist to do the dispensing. So does it mean that in the future, all the doctors will have to be made responsible for that? And that has very little to do with the bill as it stands. And also, last time during the public hearing, I also made this point. That is for pharmacies right now. Well, the entire pharmacy has already set out to be a pharmacy, but then it's also selling many other items which have nothing to do with drugs or medicine. But then it's now required that they will have to have the presence of the pharmacist before they can open for business. But then in overseas countries, very often they will have a dispensing room which has to be manned by a registered pharmacist. But then for the front store, if they just sell infant formula milk powder or just distilled water or mineral water, they should be allowed to continue with their operation. And because of the time limit, well, at present, when you look at the pharmacies, there are many out there. All right, they call themselves pharmacies, but then in the market, they are calling themselves a different name. So instead of calling themselves Yokfong in Chinese, they are calling themselves Yokfong in Chinese. So to the consumers, it's very confusing. All right, they would have thought that for pharmacies or Yokfong in Chinese, they have been approved by the administration. They have been registered. So actually, they are taking advantage of the loophole. So you will have to tighten up the requirement, or else for those who have been registered and licensed, they will find it difficult to run their business. And also, when the administration introduces such bill, they would always say that rest assured I'll be issuing guidelines and so on. All right, on the face of it, it might look very relaxed, but then by the time when you release or issue the guidelines, they would be very stringent. So the sector is very concerned about this. So can you also issue the guidelines at the same time when you present the bill?
Thank you, Mr. Fong. regarding the industry consultation I had mentioned just now. Regarding the industry consultation, we have been following up with the industry and we have consulted with different stakeholders. You recall that in December we had already held a hearing. After December, some of the questions raised by the industry were actually misunderstandings because they hadn't read the content of the bill. We had already answered them. Starting from December, when we started to promote this bill, we had not heard from the industry regarding questions. So we'd like to explain that the amendment in this bill are because of the recommendations of the review committee. There was a lot of discussion and they felt that these recommendations were necessary for strengthening monitoring of the industry. So the amendment was just a follow-up of the review committee recommendations. We understand that the industry will have concerns about amendments, so that's why we had the regulation impact assessment. So from 2009 to now, the industry is aware of all these events. Regarding the written order, I understand Mr. Fang's perspective about the doctor prescribing the wrong medicine. And what is the relationship between this prescription and order? Well, the reason why we had that requirement is because the pharmaceutical company delivered the wrong medicine and the patient received the wrong medicine. So giving a written procurement order, the Hong Kong Medical Association, they suggest that in their guidelines they require the doctors doing so. We feel that providing a written order will make the whole delivery and logistics very clear. It will prevent the issuing of wrong medicine. We also feel that from the doctor's perspective, the impact is minimal because a written procurement order, we accept email or faxes. That is considered a written order. So it shouldn't be a large problem. The Hong Kong MA also supports this recommendation. Regarding the pharmacy subdividing its area, we are aware of the concern of not having a pharmacist on the premises. If you recall, in our amendment, if they're open 24 hours, they need to have a registered pharmacist. This has been removed, so the legislation now contains no change regarding this issue. So requiring 2/3 of the time having a registered pharmacist is just an existing requirement. There's no addition. Regarding the terminology of Yokfong and Yokfong, a real pharmacist can, only a registered pharmacy can display the cross sign. Pharmacies, we understand they are the ones allowed to use the logo of a cross and the RX. Only pharmacies can use this and call themselves pharmacies. So Yokfong, they do not have a pharmacist. They cannot prescribe medicine and cannot sell other regulated products. So we understand that for some members of the public and tourists, this might not be clear. So in the health department, we have a website, it contains a list of all registered pharmacies. So if you go to the Department of Health website, you type in the name, and you can see if a pharmacy is registered or not. So we hope that this website can help the members of the public who are not clear. It could also help tourists. We are also printing some pamphlets. In the coming day or two, they should be ready, and we will place them at the checkpoints and tourist board areas. They promised they would help us distribute these to visitors such that they can differentiate which are registered pharmacies, and they can see what products are available, and we'll also educate them to tell them which products are registered and not. The guideline and ordinance, could they be issued together? No, it can't, because the amendment will empower the Pharmacy and Poison Board. If they're not empowered, they can't do that. But I can respond to Mr. Fong. When we draft the guidelines, we will consult the industry, and in fact, Department of Health and the industry are already meeting. They understand that in the guidelines in the future, they will be consulted, and some of these industry members have met with Department of Health already. The deputation meeting, we've held a deputation meeting. They have different opinions. So even if you have the latest document, we still have different views. And just now Mr. Fong mentioned the guidelines, the practice. Mr. Fong is concerned that you will have very loose legislation, but the practical guideline will be very strict. Well, we heard you say that you're consulting the industry, but do you have a draft? You can, and the stakeholders can rest assured, because they'll have something to refer to. Mr. Leung Yu-zhong. My questions are similar to Mr. Fang's. The administration says that they had consulted the industry, and they have close contact with the industry. But that is not the message we receive. Even there was a hearing in the previous panel, but that cannot be considered a thorough hearing of the industry. We have not had a thorough discussion regarding the amendment contents. When you responded to Mr. Fong Gong, you said you would maintain contact with the industry. So I'd like to ask you, what do you mean by industry? There are chambers of commerce, there are unions, and there are 3 pharmacy associations. So could you tell us, how many times have you met with them? Or what have you talked about? Because they tell us there's a big problem. There's a big topic that you have not discussed, and you won't even disclose the documents. These are so-called confidential documents. For example, the ASP, authorized seller of poisons, there wasn't a very detailed discussion. So you are being criticized as rushing through this legislation. So Ms. Claudia Mo gave this bill committee a letter. In the deputation hearings, they only express their views. There's no opportunity to scrutinize the bill clause by clause. You said that you would maintain contact with the industry. Could you tell us in the coming days, how do you maintain contact and who are you in contact with? Thank you, Mr. Leung. How many industry members have we met? Well, in CB 269/131401, in Annex 3, we had already responded. I cannot. Between July and December 2012, we had held a public consultation, and the deputations included the Dentist Association, Veterinary Association, the Consumer Council, Kowloon Chamber of Commerce, the pharmacists, and all poison retailers. That's just one partial list. In the Legislative Council document, we've listed all the industry members, but that has not included our consultant, regulatory impact assessment consultant with the industry. We also want to explain that the amendment is not made up by us. It's because of 2009, a review committee recommendation. At that time, there were a long series of meetings, and the review committee, in light of the number of incidents, they made 75 recommendations to the administration, and 16 required legislative amendment. So the history originated from that incident. You should recall the review committee had a lot of industry members in 2009. After drafting the report and after the regulatory impact assessment, and after we also drafted some industry guidelines. I've listed these in the document. I think that's the consultation. And by December last year, in the hearing, it wasn't regarding 16 legislative amendments. It was about hair dye. There were some misunderstandings, and we understand that even if you require a pharmacist on the premises 24 hours a day, so it will only be implemented when we have enough pharmacists. So since the implementation date it cannot be confirmed, we have already withdrawn that. So since December, January, February, we have not received any written submissions. I also want to clarify that some opinions calling for community pharmacies, these are not relevant to our amendment bill. It's not relevant to our current discussion. So the hearing, if you want a clause-by-clause examination of the bill, we'll do that in this bill committee. But scrutiny of bills is not done with the public, so that's why it's different from the hearing. So when we look at clause by clause, it involves some legal clauses, wording, and so on. Lastly, I'd like to say that if we have another hearing, as Mr. Leung says, we're just made to hear the industry views. But if we have another hearing, and we need to come back to the bill committee and scrutinize the bill, then we won't be able to complete the job by June. The last LegCo meeting is on 9th of July, so we will not be able to meet this legislative year deadline. Then we'll have to wait till the next legislative year before we can amend the bill. And we're trying to promote the bill as soon as possible, because there are a lot of details that need to be discussed within the guideline. So I hope I have explained clearly. It doesn't matter. We can hear from the deputations again, they can also submit written submissions. You have not set a time though. I don't know when. You should give 5 minutes or 6 minutes. Mr. Chan, initially we didn't have a lot of members with questions, so we didn't draw a line. If we were to draw a line now, so for those who have already spoken, it won't be fair. So it seems that they have taken 10 minutes per person.
So if we don't waste time on how much time should be given to each member, then we should be very quick. Yes, Leung Yu Chung. Yes, I haven't taken part in too many meetings of this council, but then I understand that only the Bills Committee will be able to do the clause-by-clause scrutiny, and only administration will be able to move amendments. But then for the time being, well, even if we are to organize a public hearing, we will only be able to comment on the overall provisions instead of the detailed provisions. For example, on the definition of ASP, I don't know if you have ever received any objections to that definition, but then in the course of the discussion, well, the sector said that they had not been given many details. So is that true? Can you clarify? And also in your earlier answer to my question, you said that you're concerned that if there is another round of consultation, then that might delay the passage of this bill. So my question is there any urgency for this bill to be enacted within this year? And if it isn't enacted within this year, what will the consequence be? What if it's only passed in the next electoral session? Will there be very serious consequences? All right, I think they've already explained. And if you want to put further questions to them, then Deputy Secretary, you will have to understand that, well, you have presented the bill, but then as to when it will be passed is in our court, not in yours. On our part, we have to ensure that we have scrutinized the bill very carefully and in detail before we can put it before the council meeting for resumption of second reading and so on. And then Mr. Leung said that at public hearings, deputations might not be able to give very detailed comments on the bill, in particular after it's been released. So it's inevitable that we will have to organize a public consultation or public hearing. But then after the hearing, will we be further inviting the deputations to come again to give us their views? Well, I have never experienced that before, but then we do have the responsibility to ensure that when the council scrutinizes the bill, we have to make sure that all the views have been addressed in the course of our discussion with the administration. All right. Well, from what I've gathered, we have to organize a public hearing, and then you said that in December after our public hearing you already sort things out with the sector, and therefore their views have been reflected in the current bill. So let's say we are very lazy, so can you go back and tell us and prepare a paper telling us which points have been made by the deputations at the earlier public hearing and which have been taken on board, and what have been incorporated in the current bill and so on. So can you give us a further paper? We are not trying to argue with you whether or not we should organize another public hearing, because we are going to do it anyway. So for the specific details that you've included in a bill in the wake of the comments by the stakeholders at the public hearing last time, so please prepare a paper and let us know. Well, there is no guarantee that we'll be able to finish our scrutiny within this year, even if we try. So we can only do it as soon as possible. But then the duty of all the lawmakers here is to ensure that we are happy with the bill before we can enact it. So why can't you do a bit more consultation? That's my question. All right, point taken. So she hasn't answered my question. Can you ask her to answer my question first? All right, it's about time to give the floor to another member. So even if they try to answer you, they would just say that they would try to do it as soon as possible. Ms. Emily Lau, well, we'll be focusing on those points anyway. Well, I'm not a panel member. The reason why I am here today, that's because there have been a lot of complaints out there. All right, at the council meeting, then they were staging a protest and demonstration downstairs, and then afterwards they also came to my ward office. And this is the Pharmacists Association in Hong Kong, and we have also got a letter, and I'm sure the secretary has circulated that to you, and that is an association of pharmacies in Hong Kong. So they are complaining that they have not been fully consulted, and they do have a lot of comments to make on this bill. In particular, they are concerned about this, and that is about the code of practice. Well, for the PPB, they hope that it's proposed that the PPB will be given more powers, but then they are of the view that the PPB is not very representative, and if you give it very extensive powers, then they are very worried. So you said that you had done a lot of work, but then how about these two bodies? Well, I'm sure they are up there in the public gallery. Even if they are not there, they must be watching the webcast of this meeting. So have you listened to their views? Because both bodies said that as soon as it's gazetted, you already started the first, second reading and so on. All right, you have, it's an established procedure. All right, they are claiming that their views have not been fully expressed. So we are not trying to make life difficult for you, Deputy Secretary, but then we find it difficult to understand. All right, these members of the public are not trying to make things difficult for you. All right, they have come time and again. So do you understand why they have had so many views to make? Deputy Secretary, thank you, Ms. Lau, for your comments. First of all, can you speak to the microphone so that everybody will be able to hear you, including those who are watching the webcast? Well, for the Hong Kong and Kowloon General Association or General Union of Pharmacies, at different meetings they've been represented between July and December 2012 with regard to the code of practice on ASP, and then July to September 2013 with regard to LSP, the list seller of poison. They've also been invited to give their views to us. Concerning the trade union on pharmacists is newly established in April this year. So has it been set up because they feel a compelling need to do so? Well, from time to time there would be new bodies being set up, but then we'll be more than happy to meet with them. And if they have any comments, then we'll be more than happy to contact them. And I'm sure some members have been liaising closely with the DFH, but then that association is a new one. Well, we have done many rounds of consultation already. Yes, they are very concerned about the future code of practice because the PPB is a statutory regulatory body, and therefore when it releases any code of practice is to regulate the conduct of the trade in order to step up or enhance the current regulatory regime. And of course, they might have concerns about their business environment. Yes, we indeed understand their concerns, and therefore, if they have any comments, we'll be more than happy to listen. That's why for the code of practice, within the last few months, we have already had many rounds of consultation with them. All right, it's already end of April, and if you want to pass it or enact it before July, then I don't know how that can be done. And of course, as far as possible, we can organize many more meetings. But then given the fact that there are divergent views out there, we will have to allow them to come and give us their views. But then it's end of April, and you're coming up with this controversial bill, and you want this council to pass it before July, and we're going to have the filibustering exercise. I don't know what is going to happen. So it's going to be something serious. So can we hold this public hearing as soon as possible so that they can come and tell us their views? With regard to the code of practice, when the PPB is to issue this, they are concerned that the PPB is not very representative and it will have excessive powers. Well, the PPB is a statutory body, so in terms of its representativeness, the DFH will arrange for professionals and those from the trade to sit on the board. So it's definitely representative because it's responsible for regulating registered pharmaceutical products and so on. All along, it's been regulated by the PPB. It's not something new because under the PPO, we have always had this PPB, and under the PPB, the consultation under Section 3, including the D of H, the government chemist, and also a doctor appointed by the D of H, and also someone with medical knowledge. So is represented by people with the know-how, and also for registered pharmaceutical products, everything has to go through this PPP, and for newly registered pharmaceutical products, that would also have to go through this statutory procedure and approved by the PPP. So it's an established mechanism. So it's a statutory requirement. There is nothing wrong with its representativeness. All right. Under the current proposal, they will be given a lot of powers. So are you aware of the outcry in the sector? Well, with regard to the code of conduct and code of practice, that's because of the spate of pharmaceutical incidents. The review committee said that for the manufacture, sale, or distribution of pharmaceutical products, there should be code of conduct and code of practice to regulate some of the procedures. But then, under the current legislation, the PPP does not have the power to come up with code of practice and code of conduct. That's why we are not able to do so. And therefore, what we are trying to do is to empower the PPP to do it. So the current problem is that the PPP does not have big enough power to do it. That's why it's proposed that it be given the power. Let's listen to the trade then. All right, Mr. Chen Hang Pen. Chairman, we know that the purpose of amending the law is to protect the public, and we all want this to be passed. But then, while we try to do it, we also hope that the regulatory impact will not be too significant, and the sector will not be too upset about this, and will be able to find out the details when we scrutinize the bill. But then I'd like to follow on from what Ms. Lau just said with regard to the Hong Kong and Kowloon General Association on Pharmaceutical Products or Pharmacies. Well, they raised some queries. So will the administration be prepared to give us a more detailed reply so that we will know whether or not you have considered their views? One of the main concerns is about the code of conduct and code of practice, and they had some serious comments about this. And one of their allegations is that you have bypassed this council, because once the power is given to the PPP, then the PPP will be able to revise the code of conduct or code of practice as and when they like it. And this council will have no say whatsoever. Hence, even the sector will not be able to voice their views in the process. So the PPP would be able to do whatever it like, and this council will have no say, and nobody would be able to have any say at all. So how do we strike a balance? So can you tell us more about this? Yes, Deputy Secretary. Thank you, Mr. Chen. In terms of the regulation of the trade, the reason why we have to have this code of conduct and code of practice, that's because the law can only set out the overriding principles, but then in the actual operation there are many details. For example, how the pharmaceutical products should be recalled when there is anything going wrong. So there are many details to be set out, and therefore, where there is any regulatory regime stipulated in the law, we often have to issue guidelines, a code of conduct, and so on, because with advancement in technology and so on, we have to update our code of practice and the regulatory regime. That's why in many pieces of legislation, we would always set out that the regulatory body will be given the power to issue guidelines in order to tie in with the developments in the trade as time goes by. But then we understand that there is always concern from the stakeholders and those who are going to be affected. But then the overriding principle is to protect public safety and make sure that pharmaceutical products are safe. With regard to the paper-based drug order, that would also be spelled out in the code of practice. So those are the details. For example, for any doctor prescribing drugs and placing order for drugs and so on. That will have to be done by way of a drug order. So these are new requirements. We do understand that some people might be very concerned about this. With regard to the Hong Kong and Kowloon Pharmacies Association, at the public hearing in December last year, they are against any form of code of practice or code of conduct. They are against having all these pharmaceutical products locked up in receptacles and so on and so forth.
We understand their basic attitude. They object to everything. We knew that in December. But out of safety concerns, we also see that there are deficiencies in current monitoring, and that led to incidents. That's why we need to strengthen monitoring. That's the situation. The guidelines or practice code, we don't have a copy in front of us, but that you want us to empower the Poison Pharmacy Board. So as Vincent Fong said, if we have a code of practice, we can make reference to where your current perspective is. And the PPB, will it be a statutory board and it doesn't need to consult with the Legislative Council? They can make amendments on their own? Or is there a framework? Is there a procedure? We need to know this PPB will not be so powerful as to do whatever it wants. So either today or in the future, could you elaborate? We're not taking sides, but we have a legislation and the industry has some concerns and we need to examine these. So if they have risen some concrete examples. Now, even though other legislation might have a similar board where they can amend the industry's code of practice, I think they have different definitions and intentions. So, but in this case, when can the PPB amend the guidelines? Do they need to consult the Legislative Council? So I think the question is this a precedent, or do we have other statutory boards to amend and draft the code of practice? And if so, do they need to report to our different legislative panels? Chairman, as I said just now, a lot of regulatory legislation has these examples. For example, the Medical Council, they can draft a lot of guidelines, and a lot of professional bodies, the so-called regulatory body, can draft these guidelines. Of course, as I said just now, these are related to day-to-day operations, the industry's situation, so they need some flexibility. So the regulatory body needs to do so, and they don't need to go through any legislative procedure. So the legislation needs to empower that regulatory body to draft these guidelines. So when the legislation empowers the regulatory body, but they cannot exceed the powers authorized. For example, if they want to regulate retailers, wholesalers, they cannot exceed the principal legislation. For example, if the legislation doesn't require 24-hour a pharmacist present 24 hours, then the guideline cannot say we need to have a pharmacist 24 hours. So the regulatory body, in this case the PPB, they need to operate under the principal legislation. And the so-called PPB, they have professional bodies. The Medical Council has nominated members. CU Hong Kong U have also nominated members. So they are related to the industry. It's not totally government appointed. So they will understand the industry's operational needs and concerns. I can only say that the guideline, I admit, it's regulatory. Otherwise, we won't need a guideline. But we understand that the board will understand the needs. For example, needing a pharmacist 24 hours on the premise. We don't have enough pharmacists, so you can't have a pharmacist 24 hours. So that effective date will be only included later. So all I can say that the guidelines cannot exceed the principal legislation. So they have their own constraints. For example, when we regulate wholesalers, importers, exporters, the guideline cannot exceed the licensing requirements. But the details would be spelt out clearly. So, since members are so concerned, could the government pledge that when this PPB amends the guidelines, they need to report back to the relevant panels? That the board, under the legislation, they have the right to draft guidelines. If I require them to report every time they amend the guidelines, so that means they have to come back whenever they have a discussion. And that is not something we can request them under the legislation. To a very large extent, I'll be overriding the legislation and monitoring the PPB. I can't make that pledge. It would exceed our ambit. Wang Dinggong. So, this is not the only bill affected by the filibustering. We are now facing filibustering in the coming 2 months, so it's very hard to do any concrete work. I suggest we have the Hong Kong Kowloon Chamber of Commerce and the Pharmacy Union. One of the bodies was present and one body was just created recently. Since these two bodies have expressed different views and they have garnered the support from, they have consulted with different legislators from different political parties. So I suggest, could you meet with these two bodies just to hear them only? They might have some new ideas for you. Could you arrange a meeting with them so you can make some concrete response to their suggestions? And second, I'm aware that the amendment, I agree we need monitoring because in the past there were problems. If we didn't have problems, then we wouldn't need to make amendments. But you need to consider the business environment, because any amendment is for the public interest. So the affected parties include the industry. They should not be hostile. They should, the patients and consumers, they work with the industry hand in hand. So when you consider regulation, you should also consider the business environment and actual operations. Can it operate smoothly? That's very important. Third, I think the legislation should not be, it should not be too haphazard. For example, we need, for example, you require written procurement orders You just want proof whether they were wrong. So will audio recordings suffice? So do we need written records? Can we have audio recordings? Can we rely on SMS apps? We have proof of error. Was the order wrong? Was the delivery wrong? Was the packing of the order wrong? So if we are to amend, can we move along with the times? Could we be more inclusive to keep abreast of technological development and communications advancements? And third, regarding the guidelines, why do we have so many opinions, and why are the operators concerned? Because the statutory body will draft the guidelines. I understand that LegCo should not take on too many responsibilities and interfere, because we're delegating the powers to the statutory bodies. But if these guidelines are drafted by the statutory bodies, then the composition of these statutory bodies can they consider actual business environment? So the composition, can it be changed? For example, have another seat or half filled by pharmacy representatives, not necessarily those from the ivory tower, so people with a profound professional knowledge. Could you allow for some lay members? So if you have lay members, it would be more representative, more comprehensive, and the guidelines could be more palatable and acceptable. So I have a series of questions, and whether you respond or think about it, so you can choose to not respond. I thank Mr. Wong for your views. You've given me a great opportunity, because I want to explain. We are willing to meet with the two bodies you mentioned. We all meet with them all the time. Regarding the guidelines, an authorized seller of poison working group, aside from official members, we have the Hong Kong Kowloon Chamber of Commerce. Mr. Lau Oikok is a member. So our guidelines are not drafted by ourselves. We have a working group, and the working group includes all the industry, including the Hong Kong Hong Kong Kowloon Pharmacy Association. They have 2 members, and we also have other pharmacy representatives. Regarding the pharmacy union, registered pharmacy behavior guidelines, one of the members, Mrs. Cheng, is in our working group as well. So I want to guarantee that it's not done unilaterally from the government's side. The working group members are transparent. We have held a number of meetings. So the guidelines will consider the business environment, will consider actual business operations, and it's impossible for the Department of Health to come up with a set of guidelines and issue them to the PPB, because all these will be uploaded on our websites. It would be open and transparent. So the consultation is, according to my records, some working groups have met for 6 times. For example, manufacturers, wholesalers are already holding meetings. So I want to explain the actual situation. I understand regarding the written order, we agree. As long as it can be email, electronic, fax, SMS, as long as it is written, we will accept that. We will take it as written. But for audio recordings, when you pronounce, it's slightly different. It could be a totally different product.
Well, sometimes if it's just a pronunciation in the a consonant in the English spelling, then the pronunciation would already be very different. That's why the requirement that the order be placed in writing is based on the actual need, so that when an order is placed, we have to make sure, we have to be sure that the name must be right, because we have to have something in writing, whether it's an SMS or whatever, so that you'll be able to find out what has gone wrong in the process. Because in terms of the logistics, for the pharmaceutical supplier, you will have to know who is there to accept the delivery. I hope that I've already explained clearly the whole flow chart. Yes, we understand what you mean, but then the purpose of this amendment is to afford better protection to the public. And also, Ms. Mo also suggested that we should do it by way of negativing. In fact, it only covers new drugs, and from time to time, the Secretary will have to come to this Council to move 3 readings for newly registered drugs. Most of these would be cancer-treating drugs, and the process would be excessively long. And then very often after that drug has been approved, and then that would take about 9 months to 1 year before any drug can be introduced into Hong Kong. And if we were to change it into positive vetting, we hope that these new drugs can be introduced into the Hong Kong market sooner for these cancer patients to use. So it's not about any other drugs. It's not about the other pharmaceutical products. So mainly we are talking about the introduction of new drugs. And we believe that that's also beneficial to the patients. And of course, we absolutely agree and respect members' views that we should carefully scrutinize the details. As we have said at the last meeting of the panel, in the light of the spate of incidents, the review committee has made this recommendation. That's why we are doing this. All right, 4 more members are asking in the first round. Vincent Fang, Li Chek-yen, Fernando Zhang. All right, Peter Zhang. Sorry, I read out the wrong name. Peter Zhang. Thank you, Chairman. I know nothing about pharmacy and poisons, and of course, if the expert says that is a poison, then of course I respect their views. But then my understanding is that on this occasion, the more controversial bits attracting more comments from the stakeholders are the process itself. That is how it operates, how it's going to operate. Will put them in a difficult position. Well, apparently, you said that the association was set up as a result of what you've been doing, because they can see that many of them have not been represented in the past, and you can see that most of the members of this new trade union are registered pharmacists are working in drugstores or pharmacies, and some of them might open their wrong pharmacies. But then under the current regulatory regime, most of the registered pharmacists are working at hospitals, and they are of the view that for hospital pharmacists, they may not have a very good understanding of the work of pharmacists. That's why when the hospital pharmacists propose any code of practice and so on. Well, they think that their views have not been fully reflected in that code. That's why they wouldn't, or else they would not have set up this new trade union in April this year. So what we are most concerned about is not whether or not that drug is a poison, but then should anything untoward happen, then who should be held responsible? That's why the definition of ASP is very important. These are the authorized seller of poison. And according to what they have told us, apparently the pharmacists working for the pharmacy will have to be held responsible. But then when we looked into that deeper, then apparently the boss or the proprietor of the pharmacy will be responsible. But then very few pharmacists are proprietor of pharmacies. And then for the proprietor, they say that, well, I have got many pharmacies. Then if one of my pharmacists has committed any problems, then it will be quite a serious problem if I have to be held responsible for each and every incident. And for the pharmacists, what if they have already signed off duty on a particular day, and if something happens, then how can they be held responsible? So it's not about whether or not a poison is a poison. It's about when it's done or is sold at a pharmacy. What's the relationship between the pharmacist and also the proprietor of the pharmacy, and how should the responsibility be delineated? And also on the code of conduct and code of practice, I agree that somebody has to come up with the code of conduct and code of practice, but then there are 3 societies, each with its own code of conduct. All right, we have the Practicing Pharmacists Association of Hong Kong, and then I've also been informed that there is no ordinance to regulate such bodies. So apparently they have no statutory role to play, and they cannot disqualify someone who has failed to observe the code of conduct. As a result, you are now asking the PPP to take up the job. That's okay, because it's a statutory body with statutory powers, and apparently you say that, well, if something untoward happens, then they might be prosecuted and they will have to appear in court. So the problem is, for these pharmacists working at pharmacies, they are very concerned about where their responsibilities would lie, and also they are concerned that the code of conduct might be issued before they have been consulted. Yes, you said that you had already got a friend or a member from the trade union sitting in the working group, but then according to what they told us, many of those pharmacists are actually pharmacists working at hospitals, and he has only got one lone voice in that committee, and he's in the minority, and therefore he's of the view that his views might not be respected. All right, Deputy Secretary, you said that you would approach the trade union directly. That's good. But then what I'd like to suggest is, can you let us know more about these societies and trade chambers of commerce and so on? What are the issues that they have raised with you, and what have you told them? So can you tell us? So can you tell us the details of your exchanges, so that for us as a third party, we'll be able to tell exactly what's been said by whom? Deputy Secretary, first of all, I'd like to explain with regard to the code of practice or the code of conduct, with regard to registered pharmacists. Well, the newly set up registered pharmacists in Hong Kong, they have 5 members sitting on our committee. We have invited them to join. Well, let us do it this way. So for all the working groups and also the membership lists, we can pass them on to this Bills Committee. So for the working group on code of conduct, code of practice, and so on, and the composition of our committee, we will give the membership list to all of you, instead of having me telling you or giving the names to you. Well, for the newly set up trade union, they've already got 5 members sitting on our board. With regard to hospital pharmacists, whether or not they would constitute the majority and so on. Well, we have 5 from the hospitals, but then for the trade union, they've also got 5. So it's a very balanced setup. We have the Hong Kong U, the Chinese U, and also the Practicing Pharmacists Association, and also the Pharmaceutical Society of Hong Kong. So all of these societies and bodies are represented. So we can give you a detailed membership list. Second, well, the reason why we are preparing these codes of conduct and codes of practice, that's because, as Mr. Zhang said, individual bodies are now coming up with their own code of practice and so on, and there is no law regulating the pharmacists because, well, the PPB has not been given the power to regulate the practice of pharmacists. That's why we are amending the law to give power to the PPB to come up with such code of conduct and code of practice so that all registered pharmacists will have to observe such code of practice and code of conduct. And then the PPB has also invited all the 3 existing bodies with their own code of conduct so that they can submit their copies to the PPB, and then we can consolidate them and come up with a consolidated set of guidelines so that under the law we will have a full set of guidelines for them. So the umbrella legislation will just set out the overriding principles, and then for the details, those will be worked out by the working group, and it will be working on a very transparent basis. That's what I've been trying to explain to you just now. With regard to the individual responsibility of the registered pharmacist, in fact, the law will not change the current regime because under the current legislation, it's already provided that in certain circumstances, the pharmacy will have to be manned by a registered pharmacist before it is allowed to sell drugs. But then there might have been some confusion because with regard to the ASP, the definition has been revised so that we have changed that to entity that carries on the retail sales of poisons. So we can ask the DFJ to explain in detail. This is a technical amendment. This is technical in nature because, well, the purpose of the legislative intent of amending it for existing pharmacist responsibility and also the pharmacy's responsibility that's already provided under the current law is just a technical amendment. So I can invite the DFJ to explain under Section 2.1 with regard to the interpretation of the various terms. Is it so technical that even the trade does not understand it? So about the definition of ASP. Thank you, Chairman. On the definition of ASP, in the interpretation clause, the amendment is just to reflect the original Section 11. It says that well, for the sellers of poisons, what kind of entities should they be? So in the original wording, in the English version, is called the business. But then when you look at Section 11 of the ordinance, it sets out the companies or the individuals who would be defined as an ASP. So we have just copied Section 11 and the persons or the companies therein. So in real terms, there has been no change at all. So when we scrutinize the bill clause by clause, we'll have a chance to look into that in detail. We'll understand that the sector is very concerned about this for ASP. Some are concerned that with the amendment, while certain individuals who in the past might not have to take up high risk will now have to take up a lot of risk. So if you can reassure us by telling us that there has been no substantial change to the meaning, then that's okay. Mr. Peter Zhang. Yes, after I've read it, I'm actually more concerned about this. It's even worse than not reading it at all. So I hope that you can use plain language to tell us what exactly does this mean. Secondly, just now the Deputy Secretary has explained very clearly about the representativeness of this working group. But then how come they are still voicing such grave concerns? That's the problem. So, all right, you might suggest that it's 5 to 5. So what's the problem? So we don't understand that. That's precise. That's why we'd like to discuss that in greater detail.
There are three bodies. There's a association, society. Do we have community pharmacists representatives? It seems that they all are government hospital pharmacists. Do we have community pharmacists representatives? The registered pharmacist behavior working group. We should have provided that earlier. There are three major associations. The practicing pharmacists. It includes so-called community pharmacists. And then we have Hong Kong Pharmacy Association, Hong Kong Government Pharmacists, that is the government hospital pharmacists, and we have the latest edition, Hong Kong Pharmacists, and each has 5 representatives. Of course, we don't rule out. Some have overlap. So why do some bodies have more vociferous opinion? The three major bodies have their own guidelines. The new ones don't have, because they were just established. So the PPB will take the existing guidelines and draft a new version. So for those who have their own guidelines, and new bodies might have their own new ideas, we're willing to hear from them. Mr. Cheung had a question that if you meet those two, the trade union and the business association, could you report your discussion with them? Yes, the Hong Kong Kowloon Pharmacists Chamber, we meet them regularly. As Mr. Wong said, we will meet them again and report their views to the Bill Committee. As I said initially, the focus is on regulation. I have a question. The authorized seller of poisons, they want to clarify. Are they referring to the salaried person or the owner of the business? They had just responded to this question. They can respond again. Chung Kok-chi had asked the question. So their concern is, do the employees have to take responsibility? So we've always had this definition, but our legal officer can respond. So is it the employee also has to bear responsibility? Under the existing legislation, before we endorse the amended bill, in the community pharmacy, if I'm an employee, if I made a mistake, will I be liable? Under the existing legislation, if you're an employee in the community pharmacy, if the owner commits some errors, will the employee also be penalized? I understand the employee's concerns, but it depends on the offense. The panel had already discussed this. For example, if the pharmacist is not aware and the owner sold the medicine, so it depends on whether the pharmacist had any knowledge. Did he participate? It depends on, first of all, which law they breached and who breached the law. So it depends on the circumstances. In 2009, the review committee identified a lot of problems. You need a mechanism to decide what can not be done. And now we have blank areas in the law, and we need to clarify that. And if we have the guideline, it will be very clear what you need to do under certain circumstances. And this clarifies the void at the time. So that's the purpose of the legislation. So for an employee, it seems that the employees need to prove whether they had knowledge of the offense. But the law but you are very business friendly in other areas. Directors need to know whether salaries were owed. You now need to, if in the salaries and arrears, the director needs to be in connivance, but there is no requirement here. So, should you spell it out to allay concerns? Well, our guidelines indicate what a person should do, but when an incident occurs, the law enforcement agency will have to bear the burden of proof. That's the spirit of the law. We need to prove who committed the error. The question now is, when there are no guidelines, so what is correct and what is incorrect? As Chung Gok-chu said, we have 3 bodies, 3 registered pharmacists, guidelines. Who's correct? There's no law that says who's correct. So our legislation is attempting to compile an objective guideline. So so the legislation is an improvement. We believe that after the working group discussion, we will compile all the experience, and that's an improvement. What I want to say is that different circumstances require a burden of the proof from the government side. So we will have to examine the guidelines. Fernando Chung. Well, I heard the government explain the guidelines are now being handled by the professionals. But inspecting more closely, the PPB has the right to draft or amend the code of practice. So these people are appointed by the CE. Are they from the industry? Some are, some aren't. For example, we have from the Department of Health, we have the government chemist, a government doctor, and a legal advisor appointed by CE, 1 from CU, Hong Kong U, and 3 from the Pharmacy Association, 1 from a Medical Association, and 1 from the UK Medical Association. So all this board is appointed by the government to monitor the pharmacy professional. Well, we would like a professional body to form a quasi-government association. For example, social workers, we have a social worker registration board, It's a statutory board. But the members of the Social Worker Registration Board are nominated by social workers. The majority of them are social workers. It's the same for nurses. You cannot return your own. So that's not ideal. But at the least, it is led by the profession. But the members, this is just now, they are not from the profession. At least it's not evidently so. So is that a difference? We agree that pharmacists are professionals. So shouldn't it be a professionally led mechanism to regulate their professional code of practice, their ethics? Whether they are community pharmacists, rather than a government-appointed framework. Under our current legislation, they are empowered further to amend the code of practice, and it has a legal effect, and that would lead to concern from the pharmacy industry. I think that's reasonable. So I want to ask the government, since you are empowering the PPB with further powers, but it seems like you're deviating from a professional body leading a professional industry. So in your next step, will you reform this PPB? Will you assist the pharmacists to set up a new board so that they can be led professionally? Well, for the last 20 years, there has been a stance of separate regulation of people and poisons. The question of, do we have a lot of pharmacists in the board? Chairman, you are correct. This legislation is not just regulating pharmacists. The board is not just looking at pharmacists. They are overlooking manufacturing, wholesale, retail, and pharmacists, including registration of new medicines, whether new medicines can be introduced to Hong Kong. So it cannot be formed by one profession. The PPO, the PPB under the PPO, and the guidelines are not just limited to pharmacists. It includes manufacturers, including the manufacturing code of practice, the standards, and so on. So the composition, as Mr. Fernando Chung said, that's why we have so many people. We also have new medicine registration. All registered medicines have to go through this. I understand the pharmacist professional regulation. It's been studied for quite some time. We already have 3 professional groups for pharmacists, and we also have a hospital medical staff working group that can be examined in that it can be examined separately. I understand. Chairman, you hit it on the nail. The legislation empowers. You are now combining 2 areas and empowering the PPB with more powers. This will affect the pharmacists. and a pharmacist being a professional, they wouldn't want the PPB to regulate them. It should be separated. But you're saying we're not separating the functions because we need to regulate everything. But is that your intention? Or should pharmacists and other professionals, should they be regulated by their own profession? If there's a contradiction in direction, shouldn't you take the opportunity of this legal amendment to rectify it?
守則
So that the code of practice, in particular the code of conduct for the pharmacists, that should be left to the professional pharmacists. At the Manpower Steering Committee is now looking into this, and the overriding direction is that that will be done in the future. But then that's not possible right now because they are still conducting the review. And under the current PPO, because the board has to do so many things, that's why when it looks at the codes of conduct and codes of practice, it has to look at many. But then for the future direction, that's as pointed out by Dr. Cheung, that's why we are not able to do it in the current exercise. All right, CAP 138 has already set out the membership of this board, but then under the board system, can you then have two separate working mechanisms or setup so that you can also revise the membership of a board under CAP 138. One part would be regulating the pharmacists, and that would be left to the pharmacists themselves so that they would be able to exercise self-regulation. And then for pharmaceutical products, that would continue to be regulated by the board so that there would be more professional autonomy. You might say that, all right, I'm not able to come up with a new piece of legislation to set up a professional pharmacist board. That cannot be done overnight, but then at least you should take a step forward in that direction. So have you got that thinking? Sorry, Chairman, I'm not able to answer that question right now. I'll forward Dr. Cheung's comments to the professional committee looking into this, because to split up the current board into two, that would also involve a lot of statutory legislation under the board. For example, for the wholesaler, the retailer, registration of new drugs and so on. Everything will have to be approved by the board. If you just split up the members into two groups, so which group will be responsible for what? So this is quite a major overhaul. It's not just about singling out the registered pharmacists from the purview of the board. Unfortunately, this ordinance is responsible for everything: drugs, pharmacies, wholesale, retail of drugs and so on. Everything is under the board's ambit. So I can imagine how complex it is. But then I'll forward Dr. Cheung's views to the steering committee, which is looking into this, because that's the overall direction. But then as to how that would be done in the future, it is now looking into it. I also agree that for the three professional bodies, that is the three codes of conduct currently under the three professional bodies, if they can be consolidated into one uniform code of conduct under the statutory regime, I think we are actually moving towards more professionalism. I think that's a very good transition. And as I said, the working group is looking into all these. And if we are able to come up with this statutory code of conduct for registered pharmacists, then they would have a new transition period to adjust or adapt to the new regime. That would also be good. Let me supplement. I think the crux of the matter now is that there are different stakeholders with different interests, and that's why there have been some conflicts. That's why they are now concerned with this. And you might say that, all right, I'm just an employee. Do I have to take up the responsibility or be held liable? But then, well, for the PPP, it's also responsible for pharmaceutical products. But then how about those practicing pharmacists? Apparently, it is also responsible for regulating this profession. So you're mixing up everything. That's why we have these problems. All right, you might say that, all right, I cannot change it overnight. But then I've been asking the working groups to look into this, even though they do not have substantive powers. But then everybody can sit down to discuss it, and when they try to consolidate the 3 codes of practice or codes of conduct into one, and if you have a very clear work target, all right, you're trying to consolidate them, and then in the future you're going to split it up, and the target is to set up a statutory body so that registered pharmacists will be regulated by one professional body, and then you're now discussing that, and you have a work target for what is to be done in the future, then that's fine. But then if you just say that, trust me, well, I've already tried my best, and I'll be doing that in the future, and I'll be leaving this to the board. So all the members will be appointed by you, and the process is not transparent as to how and whom would be appointed to the board, and the meetings will not be open to the public, and you just ask people to have trust in you, then that would be problematic. So if you're able to set out everything very clearly, if that is the direction to take, then you will have to give us more details, you will have to give us a timetable, and then there'll be room for us to discuss it with you. But then that might not have any direct bearing on the current bill. But then I hope that the administration will be aware that actually you might be over-regulating, and that's why, well, the future direction is that, well, for the body to regulate the practicing pharmacists, that should be done by a professional body, and then the board would only be regulating the products. But then unless you require them to draft it all over again, and then one would be responsible for regulating poisons and the other would be regulating the professionals, or else that cannot be done. Yes, Ms. Elizabeth Quat, I think there is a necessity for us to have this bill, because there has been a lot of public concerns on this. We would like to see an enhanced regime on the regulation of pharmaceutical products. But then, as some members have pointed out, that we have received comments or voices from different bodies, and we can see that the consultation has not been adequate. That's why we're going to organize a public hearing, and then the Bureau said that they would be communicating with the stakeholders. So what's your plan? So are you going to consult them again and then you come back to talk to us, or are we going to organize a public hearing, because there might be implication on the time when this can be enacted? Well, for pharmacists, I think they are most concerned that the board might have too many powers, because everything will be done by the board and is responsible for regulating both the pharmaceutical products and the pharmacies. And then in the future, you don't have to come back to this council for further amendments, and you will have unfettered powers, and there is no checks and balance. So would the administration consider adopting alternative approaches so that the sector can be rest assured that they will be involved in the process? For example, for some professions, some of your members can be appointed by the administration, and some can be elected amongst the professionals themselves, so that in terms of the regulation and the amendment to the code of conduct and so on, they will be involved. Well, for the public hearing, we have made up our mind already. So whatever the administration has to say, we will be holding this public hearing anyway. So what is your view on the concern that the board might be enjoying excessive powers? Chairman, I'm afraid I might be repeating myself already. In fact, the board does not have the power right now. That's why we are asking for the amendment in order to give it the power to come up with the code of practice. And what's happening right now is that we have 3 professional bodies, and the 3 professional bodies have their own code of practice and code of conduct for their registered pharmacists, and the situation is not desirable. So what is being proposed now is to give the PPB the power to come up with different codes of conduct and codes of practice. That's because of the recommendation of the review committee in the light of the incidents, so that they can have these various code of conduct and code of practice, so that everybody will know what role they should be playing. For example, for pharmacies, they will have to keep records and how certain drugs are being kept, so that when there is a recall, you will at least have to know what's the inventory in your store. So these will have to be spelled out more clearly. To suggest that the board might have excessive powers and there are concerns that they might be doing things without consultation. No, that's not true, because at present they are not able to do that. And in the future, when they attempt to do this, well, what we've been doing has already shown that all the stakeholders are already represented in the relevant working groups, and for the 3 professional bodies, their code of conduct would also be placed before the working group, and they will be consolidated into one, so that there can be a consensus on what code should be introduced. So that's to improve the current situation, and that would also clarify many of the ambiguities. All right, A might think that this is right, and then B might think otherwise. So we believe that this is a good direction to take. And then for raw, the existing codes of conduct, in the future there will be high degree of transparency. Everything will be uploaded onto the web, so that everybody will know what to follow. And then for the professionals, they will have their own set of guidelines, so there will be some common guidelines for everybody to follow. That's the reason why we have to amend the law. With regard to the current situation, the PPB, under the current legislation, is not able to do many things, and that's why we are trying to enhance the regime. That's why the response from the sector is that they are very concerned about this, because with the revamping of the regime, obviously there will be tightening up of the existing rules and regulations. That's why they are very concerned about this. All right, Paul, next, Paul Chair. I'd like the Deputy Secretary to tell us more about this. Under the current regime, in order to enforce the law or the subsidiary legislation, yes, you have already got a board here. But then before then, without the code of conduct and code of practice, what would they do? So are we trying to regularize these codes of practice and codes of conduct, or tighten them up? So I'd like you to elaborate on that. Next, as some colleagues have said just now, should the direction be like this, as Dr. Fernando Jiang just said? So should you be moving towards more professionalism, so that a professional body be given the powers to do the job? So is that the direction that you're taking, or are you going in a different direction? Because at present we have some professional bodies in the past that they have been given the power to regulate their own profession, but then the trend has changed worldwide. We are actually trying to nationalize these. For example, in the UK, their law society is now experiencing many problems, and therefore we may have less professional bodies. For example, insurance, real estate, and even the tourism sector. In the past, they used to have self-regulatory body, and now we are asking statutory bodies that are not from their own trade to regulate these professions. So is that the direction to take? Well, at present, we do not have a statutory body issuing these guidelines or code of conduct. So as to how they are currently being regulated, I'll defer to Ms. Wu. Well, if you look at the current legislation, all right, the board is the licensing authority. So for manufacturers, they will have to be licensed. So through licensing conditions, they'll be regulated. So by issuing a license to these pharmaceutical companies, so they would be subject to certain licensing conditions, and at present they are required to comply with GMP requirements. Even though the board has not spelled out this in the form of a code of practice, but then we do have the GMP guide, so they also have to comply with the GMP requirements before they can be issued a license. So that's the way we regulate them. And then for wholesaler, at present we are drafting some guidelines which we do not have now, so they will be regulated, they will be given a license, and then the license would allow them to sell only import or export, wholesale and retail, so they would also have to comply with certain record keeping requirement, and then in terms of storage of the product, they would have to have a proper storage so that the pharmaceutical products will not deteriorate in quality.
We're just clarifying, and in our discussions, we take existing practice and we are just putting it in writing. So that's why we have the industry, and they're just taking some common practice. The rooms need to be clean, there should be air conditioning, humidity, temperature requirements. So that's what we're talking about, and we want to clarify that and compile guidelines. And in the process, we will sit down with the industry and draft these guidelines before submitting this to the PPB. The PPB, they will have some questions and they will have open consultation. And this code of practice will be part of the public consultation process. We'll deliver this to different bodies and we'll solicit their views. After compiling the views, we'll see what needs to be amended, and that would be delivered to the PPB again. They will take on board public views, industry views, before endorsing the final code. These procedures will be open and transparent, and the code will be uploaded to the PPB website for public scrutiny. So that is the practice currently. So I hope that legislators can understand the PPB is not drafting it behind closed doors. How do you monitor pharmacists? That's the same. Do they have guidelines? No. So now we're drafting guidelines. There's a working group where we've invited the 4 pharmacist groups in 2014. In the last month or two, there was a new body established, and we've invited them. We've indicted them with the Pharmacists Union and the working group, and the working group includes the 2 universities because they have a pharmacy course. The working group will draft a behavior code for pharmacists. We now have 4 associations and 2 universities. There are some 20-odd people in the working group to draft this code. So, should it be government regulated or industry regulated? Well, this is a complex issue. Even though we're digressing a little bit, pharmacists are different from doctors and other medical staff. They interact with the retailers. Let's say if we don't have a registered pharmacist, they can't sell certain medications in a pharmacy. So when you regulate them, you're not just regulating their profession. They also involved with a certain pharmacy, and they're also related to registering new medicines. So even though the legislation is very old, and under one legislation they regulate manufacturing, retail, wholesale, but all the people are related. The medication is not just prescription medicine, it's related to the manufacturing, wholesaling. When you deliver the medication, the pharmacist's role, there are regulations regarding over-the-counter sales in pharmacies. So can we just look at it in an isolated light? What about the relationship with the business? And our pharmacists are not working in pharmacies, some work in hospitals. So the regulatory framework is different. Well, doctors have clinics, lawyers have offices, there's a place and a person. There's nothing new there. But perhaps you should give us some background information. You're just taking haphazard measures and you're trying to standardize and regularize it. You're just so you should clarify it for us. And second, pharmacists, there were 3 or 4 unions in the past, and you want to standardize them, make it uniform. So, is my understanding correct? You're correct. The code of practice for pharmacists, even though there's no code of practice in writing, but the different registered pharmacists know what has to be done by force of habit and custom. But we need to have a consensus that is something recognized by the whole profession. That's why we need a code of practice, because as time changes, as practice changes, things will change. So set aside registered pharmacists. Let's talk about wholesaling. In the past, we didn't regulate wholesalers aside from poisons, so they didn't need to keep records. But now, we will require them to keep records as if they were wholesalers of poisons. Even though it's not a poison, but if there's a problem in manufacturing and they need to do a product recall, we need to have records. Who they sold to, who bought them. So these guidelines in this future, a wholesaler will need to do such and such in order to get a license. So Mr. Palte is correct. It's consolidation. But we're also giving the PPB an opportunity where, out of public safety concerns, we can strengthen our regulatory regime. Well, we've had a detailed discussion this afternoon, and we're concerned about a hearing and the written order And we're also concerned about ASP. Is it comprehensible? And we also talked about the code of practice. And there are also other concerns. So I would suggest here we need a hearing. We'll set a date, a next occasion. And after the hearing, we can hopefully enter clause-by-clause scrutiny. And I have a suggestion for the administration. We have some technical matters. So there's a CB2 1314/01 in Annex 1. There are reasons for amendments. So I hope you can tell us what needs to be amended, what suggestions have been made, and we also need to understand the industry views. And you have to tell us what you have done to assuage their concerns, because this is a complex bill, so we need to strike a balance. When we enter discussion, we have a better grasp of and we can be aware of your response. And before the hearing, if you've met the two bodies, could you please update us so that members can grasp the whole bill, the concerns and government responses, and then in clause-by-clause scrutiny we can clarify them and clear them up. If you look at the brief in Annex C, we have recommendations and the government response. There is a list there. Could you also include industry concern, industry objections? Okay. Well, if you've followed the health panel, you should be clear. So if the government can do its work, it can facilitate our discussion. So we'll adjourn here, and we can set the dates for the hearing and meeting next week. We have to attend the council meetings, so hopefully we can run through this smoothly. If you want to invite participants, please notify the secretary. Thank you.